Testing one, two, testing one, two. Just so that you all aware, you probably got to get about this close to the microphone to get a good sound, okay?
Testing,
And push the top.
I don't have to get
testing. All right.
test one, two, test one, two.
Okay, Director Bell tells me we're ready to go. Is that right? Okay. I mean, yeah, Pat's giving me the thumbs up too. That means public has access to what we're doing now. So I guess we're ready to begin. Well, we'll begin by the roll call. Now I see everybody's here, so it's a silly exercise, but we'll do it anyway. Mr. Carmen. Here. Mr. Eggers. Millen.
Here.
And Mr. Lewis. Here. Here is here as well, so we're ready to go. We'll begin as we always do with conflicts of interest. Does any member have a conflict of interest that would preclude their full participation in today's proceedings? Seeing none, we'll move on to approval of minutes.
Mr. Chairman, I would have one correction in our first set of minutes. It references my wife's work with Legal Aid, and as of the date of that meeting, she was not employed with Legal Aid, but works with the Family Law Office.
Eggers, 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 and Eggers.
Yeah, eponymously so. With that one correction, I'd make a motion we approve the minutes as presented.
I second.
All right, moved by Mr. Eggers, seconded by Mr. Carmen. All in favor, say aye.
Aye.
Opposed, nay. It's unanimously adopted. And we're ready for the canvas. Karen, this is you.
Thank you, sir, and thank you, board members and members of the public for being with us today, and also bearing with us as we work through our new technology system and our first in-person board meeting that also has audio and visual to display for the public. So hopefully all of that is working properly. We are here for a very important meeting today, and this is one second. Should it be displaying back there or just here? Okay. So this is the canvas and certification of the 2024 general election. That is why we are specifically here on this date at this time, in addition to the other matters that you will consider today. So the general election was held on November 5th, 2024. And in this particular election, we broke another record. We had the most ballots ever cast in North Carolina elections history, with 5.7 million ballots cast, which is approximately a 73% turnout. We did not break the turnout record. That was set in 2020 when it was 75% turnout. We are actually trending towards more participation by North Carolinians. I pulled information from prior elections. We actually can go back many decades on turnout, where we have seen from 79 on that generally North Carolinians have been turning out in the 50-some percentile or 60-some percentile. So to cross over into 75, 73% in the last two presidential elections is pretty significant. And we also have seen an increase in our population and therefore an increase in the number of registered voters. In 2020, we crossed over 7 million and had 7.3 million North Carolinians participate in the election, and 7.8 million participated in, were registered for this election. We also have been tracking the voting methods that North Carolinians are choosing to use in the elections. And we have made sure to include not only the 2020 voting methods, but also 2016, because 2020 being the year of the coronavirus pandemic definitely changed the voting patterns of our voters. So if you look, we have continued to see an increase in absentee by mail usage. Not quite 200,000 voters voted in that method in 2016. We went over 1 million in 2020, but obviously the pandemic influenced that. And then in 2024, for this election, we almost reached 300,000 ballots cast absentee by mail. We've also continued to see strong interest, and the most popular voting method be early voting, and that continues to trend up to where we broke another record and had over 4 million North Carolinians cast their ballot during the 17-day early voting period. With this election, we had over 1.2 million ballots cast on election day, which is certainly, it's the second most popular form of voting, though that was not quite the case in 2020. So that just gives you some overview. I did not choose to give a Hurricane Helene update since we had done that at a meeting just before Election Day. But certainly that's another headline of this election is that we had 25 counties affected by Hurricane Helene, and yet we still were able to deliver voting and had the roads to the isolated areas opened by Election Day. So a tip of the hat to our colleagues in North Carolina Emergency Management, DOT, so many who helped to make that possible. So today's purpose is to go over where we are with the outcome of the November 5th, 2024 general election, and for the board to canvass to authenticate the vote in all contests and then authorize the issuance of certificates. There are some key statutes, both federal law and state law, that pertain to canvass. And so that, not to just read to you, but I think it's important because the public often doesn't understand the significance of this meeting and the role that not only state board members play, but county board members play. So the Voting Rights Act of 1965 even indicates that no person acting under color of law shall fail or refuse to permit any person to vote who is entitled to vote under any provision of this act or is otherwise qualified to vote, willfully fail or refuse to tabulate, count, and report such person's vote. So that would be a federal crime if we were to violate this section of the Voting Rights Act. Then in General Statute 163-22, item H, it shall be the duty of the State Board of Elections to tabulate the primary and election returns, to declare the results, and to prepare abstracts of the votes cast in each county in the state for offices which, according to law, shall be tabulated by the State Board. And then in 163-182.5, two sections go further into the meaning of canvass, which is the process of determining that votes have been counted and tabulated correctly, culminating in the authentication of the official election results, and defines that we are to meet at this time and this day. And then the section 163-182.15b, if in the ballot items within the jurisdiction of the state board shall issue a certificate of nomination or election, and that we will do so within 6 days, unless there is an election protest pending. So we will go through the audits and the preparations we have made to prepare for this canvass meeting. The counties have been meeting in their canvass period, which was 10 days following the election. In that time frame, they did a sample hand-to-eye audit as required by state law following every election. They've worked on their reconciliation. We'll go into more detail on that. And then they've confirmed the eligibility of ballots that all eligible ballots have been counted. And so that includes ballots that weren't unable to be read in the precinct because of ballot jams or torn ballots, something of that nature. They have addressed absentee ballots. There was a provision where counties affected by Helene or voters affected by Helene could deliver their absentee ballots to counties offices anywhere in the state. And so some of those were delivered after Election Day and have been added into the totals, for example. And then we have military and citizens living abroad whose ballots can be accepted later in the canvass process. We have provisional ballots that they have to research and determine if they are eligible to be counted. And then they went through a process of removing ineligible ballots. And we'll talk a little bit more about that addition to our processes. And at this point, our state office has been auditing voter history with the counties and reviewing that sample hand-to-eye audit in an aggregated statewide review. So I mentioned that we added in some additional steps for these counties. We did a series of queries to identify possible early vote and absentee voters who cast a ballot in the election but may not have been eligible. And it's then up to the counties to research this. So our query didn't necessarily guarantee that these individuals need to be removed, but for the counties to determine, research each individual case, and then if they did need to be removed, then there was a challenge process that was part of their canvas. And so those queries gave them information on individuals who may have had the same NCID with multiple votes, removed voters with votes, potentially individuals who were denied voters with votes, exact duplicates that may have had votes, and then individuals who had been convicted of a felony or who had died after casting a ballot and needed to be removed. So the counties did research on that. They were not always to be removed, but they did remove those that did prove to be an ineligible ballot to be counted. This also included the change in North Carolina statute regarding same-day registrations, and if a same-day registrant's verification card was returned, then the board had to consider whether that ballot needed to be removed as well. So that's among those queries. We also did our voter history audit, which has been an ongoing audit for many years now. This is where we work with the counties to compare the number of authorization to vote forms, the check-in poll book system, and that absentee applications, which is that absentee voters check-in, with the number of physical ballots that were cast. These generally should match, but there are circumstances where they do not. In the midst of completing all of this work with the most ballots ever cast, the counties have diligently worked to complete voter history in time for this meeting, and nearly all have done so. There are a handful of counties that are left, and we anticipate they may even be finished today. I know Guilford worked until 10 o'clock last night trying to be ready for today for y'all, and they're not quite there. So with that, we know that 15 counties matched exactly. So the number of voters that checked in and the number of ballots cast matched exactly. We had 56 counties that have a difference of 5 or fewer in all of the ballots that they had cast. And then we had, there were across the counties for who had a variance greater than 5 or among those 5 variances, 865 ballots, or on average 9 ballots per county where there was a variance, a difference. And so we asked them to explain those differences. And in this particular election, there were 2 issues that seemed to be the overwhelming theme of why they had these differences. I know in one county, they had 9 voters to check in and then walk out without casting their ballot. That's particularly high. We see that more often in primaries because they don't get the primary ballot that they think that they want or should get. But in this particular election, we saw a larger number of situations where voters did check in and walked out without casting a ballot. We also saw an increase in the number of voters or workers inserting their provisional ballot into the tabulator rather than into the provisional envelope. And unfortunately, these generally occur on election day, and the provisional ballot had not been indicated as a provisional ballot. So determining those ballots from other ballots that should have gone into the tabulator on election day is not possible. So that's where we see the greatest variance and circumstance of issues. But then we have other situations where, again, there were a number of counties that were able to get it down to an exact match or very few differences. Still, in reviewing this and understanding what these differences were, we find no evidence of vote totals or ballots cast being manipulated. So we still feel confident in the voter history audit and putting that before you. The sample audit, which is the sample hand-to-eye count to verify that the tabulators did perform accurately in this election. We do this audit, this process after every single election, whether it's a presidential or a municipal election. That has been part of North Carolina's law since 2006. And with this, we do a random selection on the day after the election. That's done here at the state board and then distributed to the counties. They do a hand count of usually 2 groups. So it could be a precinct, it could be an early voting group, it could be absentee by mail. And they bring in bipartisan officials to do this hand count of the top contest on the ballot. So this year it was a counting of the presidential contest. The way that random selection broke down this time, there were 156 election day precincts selected. We had a few more early voting sites selected this time. There were 28 that were hand counted. And then we had 16 counties that counted their absentee by mail ballots based upon the random selection. So there were 200 samples, and that generated more than 260,000 ballots that were hand counted. We found 75 differences between the machine count and the human count in 23 ballot groups, and that means there was an average difference of 3.3. The differences generally were human error, being the voter not properly marking the box or the oval beside the candidate name, or doing so with a check mark or a dot or something that the tabulator is not able to read correctly, or human error in hand count. We continue to find that tabulators count better than humans. And so in 177 of the samples, it was an exact match. So again, the tabulators performed accurately. We have included in our post-election audit report a more detailed explanation to the sample audit. We started doing this with the last election, so the public can be well aware of which counties had a difference in their hand-to-eye count, and also the explanations to it. And so I've just pulled out one example. Moore County had a difference of 1, and it was where a ballot was accidentally counted twice because the tabulator jammed and the precinct official inserted the ballot again, what they were able to determine. So, so with that, I am happy to go into the actual certification. That completes the audit review. So we are putting forward to you that the counties have canvassed and finalized results, except for contests that are subject to a recount. We would ask to issue certificates of elections to the prevailing candidates. We have those ready for signatures, and we will issue those 6 days after the completion of this meeting, except for you do not issue a certificate in the presidential contest. We are certifying the electors for the Electoral College today. We will not issue a certificate in contests that are under recount or contests with pending protests. And we will have you to sign a composite abstract that will be filed with the Secretary of State as according to law. Those contests that are currently under recount, there's a handful. This is less of a list than where we started into this process, but we are now still under recount with the North Carolina Supreme Court Associate Justice Seat 6. That is a statewide recount. The others are not statewide. They are the Senate District 18 that affects Granville and Wake, Senate District 42 that affects Mecklenburg, House District 32 affecting Granville and Vance, House District 105 affecting Mecklenburg, the Cabarrus County Board of Commissioners contest affecting Cabarrus County, Pitt County Board of Commissioners District C, so that is a recount in Pitt County, the City of Trinity City Council Ward 3 is being conducted as a recount in Randolph County. Then we have Rowan Salisbury Schools Board of Education, seat 5. That's in Rowan County. And then the Wilton County Board of Education, District 4. Wilton County is conducting a recount with that contest. So with that, this is the suggested motion for the board, that you would canvass the votes and cast in all ballots in the November 5th general election within the jurisdiction of the state board, except for the contests under recount, and that you would authenticate the composite abstract. So I will answer any questions that you might have and leave the motion to you as the board.
Members of the board, questions for Karen?
Mr. Chairman.
Mr. Eggers?
Ms. Bell, just to be clear, all 100 counties have completed their canvas. Is that correct?
They have completed their canvas. The voter history is not a requirement before they complete canvas. We do work with them to try to get it to that point with our canvas, and we're almost there.
Do we anticipate any significant issues in the 7 counties?
No, they are pretty close to done, so we've been tracking that they are just in the process of continuing to reconcile. Some of those do not use electronic poll books, so they are still in the process of scanning barcodes from the labels that are on their ATV forms.
And the, I guess, last question I have related to our canvas would be, as to the suggested motion, would this exclude those that are also under protest currently? I know we have some pending protests that are unresolved, or does this motion need to only reflect those contests under recount?
We do not issue the certificates for the protests that are pending, but we can certify the vote. Is that, Paul, would you like to speak to that further?
That's right. The pending nature of a protest means that we don't issue certificates of election to the winner. It does not prevent the canvassing of the election. The canvassing of election is ascertaining what the vote totals are and certifying those. But a protest will stay the issuance of a certificate of election until that protest is resolved.
If part of the protest is to correct the vote count, would that still be undertaken even if we vote in favor of canvas?
As I read the statutes, it could be undertaken that way after the fact, because the statutes say that, you know, it shall not delay the canvass, but that the other statute that governs protests says that the board has the authority to correct the election results in adjudicating protest.
So just to be clear, is it your advice to us that we can proceed with an affirmative vote for canvas, and that would not affect or disturb the content of any pending protest that's properly filed?
That's correct.
All right, thank you, sir.
Okay, other members of the board, questions for Karen?
Mr. Chairman,
Yes, Mr. Lewis.
following up on Eggers' questions, how many contests are in this protest situation? You have that in our materials?
It's not in your materials, but I can attempt to find that for you.
Wasn't there a slide with all of them listed?
That was the recounts.
That's what's on page 6 of the materials, but that's just the recount numbers.
So there is a, let's see. And not Castile. 2. We're counting 8 contests that are under protest right now.
And is that 8 above and beyond the ones that are in recount, or some of them?
No, at least one of those is under recount. I know that the state Supreme Court contest is under recount, and that also has a protest pending. State Senate District 18, which is under recount, also has a protest pending. NC House District 32 also has a protest pending. NC House 105, that's not it. That's not McGinn, is it? Yeah, never mind. Disregard that. None of the other contests under recount have a protest pending, just those three.
Thank you.
Yes, sir.
Okay,
Senate District 42.
other members of the board? Discussion.
One correction, that was 4 of those, so the top 4 listed in the counted contests have protests pending as well. So I think I skipped over, see Senate District 42, which is in Mecklenburg.
Okay, thank you, Paul. Members of the board, any comments, questions?
Mr. Chair,
Yes, Ms. Millen.
I would just like to commend the board, staff, and the county staffs. I think we had a very well-run election. There were a couple of things I would have liked to have seen done faster or in different orders, and we can all talk about that when the dust has settled. But I think overall, especially considering the damage that we saw in the western part of the state, I would just like to commend Karen and the staff.
Yeah.
Thank you, Member Mellon. The credit goes to definitely the staff and the 100 County Board staff members who have worked. I think they're all still working, in many cases, 14, 16-hour days and have been since the start of early voting to keep this going. There were many more steps for them to do during this canvass than in prior elections, and then to have such a tremendous turnout. And then, as you mentioned, 25 of those were working through disaster recovery. It is really exceptional what they have done, and in the professional manner that they have done. And the county board members as well, because it's been a lot of long hours for them. Absentee board meetings that were going until 11 o'clock at night, and members who we've already have some vacancies in a couple of counties, and so they have been conducting recounts themselves or with new staff members. And it's, and this was an election where we had more than 30 directors. It would be their first time as county director for a presidential election. So it is pretty phenomenal. And I, well, quite frankly, respect the hell out of them for what they've pulled off. So.
Yeah, we're all very proud. Okay, ladies and gentlemen, is there a motion?
Mr. Chairman?
Yes, Mr. Eggers.
Mr. Chairman, I would move the state board canvass the votes cast in all ballot items in the November 5th, 2024 general election within the jurisdiction of the state board, except for Supreme Court Associate Justice seat number 6, NC Senate District 18, NC Senate District 42, NC House of Representatives District 32, NC House District 105, the Cabarrus County Board of Commissioner race currently under recount, the Pitt County Board of Commissioner seat C, the City of Trinity City Council Ward 3, the Rowan Salisbury School Board of Education seat number 5, and the Wilson County Board of Education District number 4, and would further move that the board authenticate the count as displayed in the composite abstract prepared by staff in every ballot item for the general election, except for the aforementioned contest, and that we do so with the thanks of this board to the state staff, to the county staff, and to all 500 of our county board of elections members, as well as those in emergency management and the National Guard and all the volunteers that have helped pull this off and get us where we are today.
I
I second.
second.
Okay, moved by Mr. Eggers, seconded by Ms. Millen. Further discussion? Hearing none, all in favor say aye.
Aye.
Opposed, nay. Motion carries unanimously. Staff, pretty remarkable work. All right, the next item on the agenda is a protest appeal for the Rutherford County Board of Commissioners, District 2. Adam, this is yours, I think.
That's right. Thank you. So the next item is the protest appeal out of Rutherford County. As you mentioned, it's dealing with the Board of Commissioners District 2 contest. In that contest, there was just a single candidate, and the protest was filed by a registered voter who lives in that district, in District 2. The protest was filed before the election, and one of the provisions of General Statute 163, 182.9, the protest was stayed automatically until after the election. Once, after Election Day, the county board, the Rutherford County Board, they conducted their preliminary consideration meeting. And at that meeting, that's where the county board will decide whether the protest meets the procedural requirements under the statute, and then also whether it sufficiently alleges probable cause of violation of election law, misconduct in the election, or some kind of other irregularity. And it's sufficient to change the outcome of the contest. And like I mentioned, there was only one candidate in this contest, and probably the best way to describe the allegations in the protest are that that candidate does not reside in the district, in District 2, and therefore it was not eligible to be elected to that seat. And so the protest alleges that instead his residence was in District 5. And so I'll just go through a few things with the protest. What happened with the county board is they decided that the protest sufficiently complied with the procedural requirements of the statute. And then, but when it came time to decide whether it met the probable cause standard, the county board said it did not meet that standard. And so after its decision was filed, protester, Mr. Keith Hunter, he appealed. That appeal was timely received here at the state board. And then both the protester and the candidate involved, Mr. Donnie Hawk, they were given the opportunity to provide a written statement about the appeal. And so those statements have been received, they've been provided to you all, they've been posted on our website. And in the appeal, Mr. Hunter, he raises what he could describe as two procedural issues and then probably one substantive issue. So the two procedural issues that he raises, one is that the burden of proof was not properly placed on the candidate in the election. The other one is that he wasn't allowed to present any kind of testimony or speak at the preliminary consideration meeting. And then the substantive issue that he raises is pretty much that he should have been able to go on to an evidentiary hearing, which would be the next step in the process if a protest isn't dismissed at that preliminary consideration meeting. Now, with for Mr. Hunter, with his written statement about his appeal, he did include a request to add to the record. And so there he had a couple documents. One was an email that he received with some attachments. Another is a news article. And the third item that he asked to be added to the record on appeal is a recording of a radio interview where Donnie Hawk, I guess, spoke to some radio hosts in the aftermath of Helene. So he asked that to be included on the appeal as well. So that's one initial matter for the board to decide whether to supplement the record or just decide the matter based on what the record was below for the county board. If you'd like me to, have any questions for me, happy to answer them. I can go further into just those procedural issues. One thing I will note is that there was a candidate challenge to this candidate. And so when the candidates filed for the primary back in December of last year, a voter in the district challenged the candidacy of Mr. Hawk at that time. And there was a hearing before the county board in January, and they dismissed that candidate challenge at that time. And so, but this is a protest. And so there is overlap in the issue that's being alleged, but it is a little bit different, and I can go into that if you'd like me to.
Okay, members of the board, comments or questions for Mr. Steele?
Chairman?
Mr. Eggers?
Mr. Fields, as I read the prior decision that was issued in January of 2024, it appears it dealt with the issues of whether there was an actual abandonment of a domicile and then an establishment of a new domicile. Many of the items related to this protest seem to retread that same ground that was laid and decided at the January 2024 hearing by the county board. To what extent would that order be res judicata for consideration later, since the board at the county level has already determined where the domicile was as of that date?
So this actually came up this summer, just kind of in reverse order with a different candidate challenge. So there was another contest, it was a municipal contest, and there was a candidate, and there was a candidate challenge against him saying he doesn't reside there. That was this summer. There had previously been a protest about that same candidate from 2022, and there the protest again it dealt with the same thing about residency within the district. And the issues there, and I bring that up because it kind of highlights the issues here, is that the matter that was decided back with the candidate challenge here for Mr. Hawk was about his residency in December, so at the time of his filing. Here, the protest is talking about where he resides today. So it would be something to consider, but I don't think it would conclusively decide the issue.
Thanks, sir. And procedurally, should we deal with the request to supplement the record first and deal with the substance of the appeal?
That's how I would suggest proceeding.
Thank you, sir. Thank you, Mr. Chairman.
Other members of the board?
Mr. Steele, is it fair to sum things up by saying Mr. Hunter brought people with him to the preliminary meeting who were not allowed to testify? And then at the next phase of the hearing, the board said you didn't have enough evidence in your protest, basically on paper, so we're going to dismiss it. It seems to me like the protester's getting a little bit whipsawed here. Is that a fair summary, or am I missing something?
So at the preliminary consideration hearing, the county board, they're reviewing the face of the protest, anything included with it. There's no witness testimony there because essentially it's determining did you put enough in there to move on to an evidentiary hearing. So Mr. Hunter's expectation of being able to have witnesses testify there is mistaken, but it doesn't mean you have to put all of your evidence into your protest to begin with. That's the whole reason why there's an evidentiary hearing. So, what would have happened is he would have been able to, if they moved to an evidentiary hearing, he would have been able to have those witnesses testify on the matter.
Mr. Chairman. Mr. Lewis. All right, my question is, are we being asked in this appeal to decide whether or not that protest met the probable cause standard, and therefore the county board should have proceeded to an evidentiary hearing? Is that what we're being asked to decide on this appeal?
That's right. You're not deciding the merits of the appeal. It's just you're reviewing the county board's decision.
Okay, discussion. Board members, you're being exceptionally quiet on this one.
Mr. Chairman, I'll start on the request to supplement the record. The email doesn't appear to have a basis or chain of custody since it's apparently anonymous information. So I don't know what information would be added to that. I have a particular dislike for folks trying to prove facts by news articles because that's the very definition of hearsay. So as to those two items, I would suggest we vote to not allow those items to supplement our record. As to the radio interview, I'd be at my colleague's persuasion perhaps as to whether we allow that to be included as part of our record for our purposes.
Mr. Steele, the radio interview, do we know anything about the substance of it?
I mean, I listened to it. It's an interview with Mr. Hawk. I don't think there's any dispute that it's Mr. Hawk on the radio interview. He's talking about the aftermath of Helene and efforts that are being undertaken in the community to kind of rally everybody together and take care of each other. I think you could take what you want from it. It's about 13 minutes long.
All right. Is there a suggestion in there about where he lives?
So he's described as a Forest City resident, and I would say he probably holds himself out there as one, but it's not really conclusive either way. Sorry to be wishy-washy on that, but.
Okay, understood. All right, should we move on? Want to make a motion?
Yes, Mr. Chairman, I would move that the State Board deny the supplementation of the record as to the email and news articles, but allow the radio interview to be included as part of our record.
Is there a second?
I'll second that.
All right, moved by Mr. Eggers, second by Ms. Millen. Further discussion? If not, so many as favor of the motion say aye.
Aye.
Opposed, nay. All right, it carries unanimously. Adam, what's our next step here?
Now the board would need to decide whether, to essentially grant the appeal and send the matter back to the county board for an evidentiary hearing, or to deny the appeal, which would have the result of essentially affirming the county board's decision to dismiss.
Okay, members of the board.
Mr. Chair, I would give weight to the prior decision that was held in January of 2024. I don't see information in this protest that would set forth facts to say the domicile had been changed after that date to a different location. So I think giving weight to prior decision would be prudent, and if we do that, then I don't see that this necessarily establishes a probable cause for a hearing.
So is that a motion to deny the appeal?
Yes, sir, Mr. Chair, I'd make a motion that the State Board deny the appeal based upon the prior decision of the County Board from January of 2024, and in light of the remaining evidence that it does not establish probable cause to believe that there had been an actual abandonment of that domicile after that date.
Okay, Mr. Eggers moves. Is there a second?
I second.
Second by Mr. Carmen. Further debate.
I think there was evidence somewhere in there, though, that Mr. Hunter says he knows or has information about where Mr. Hawk lives. Is that right? I mean, how are we to kind of weigh that in the balance?
It's directed to me or Mr.
I'm
Steele.
asking Mr. Steele. Well, I'm sorry. I'll ask both of you. I'm not sure it's really ever been examined, the whole information about where this man lives. So I'd be inclined to grant the appeal. You want to weigh in on that, Mr. Steele?
So the allegations in the appeal in the protests, it includes the face of the protest. He has a longer statement with that. He does speak to, kind of mixes the candidate challenge where he is talking about what occurred before, but it does also talk about Mr. Hawk's current domicile, and that he has witnesses who will talk about where Mr. Hawk is essentially treating, which of his properties he's treating as his current residence. There doesn't seem to be much dispute that Mr. Hawk does own numerous properties, or at least multiple properties, and spends time at different ones. So And then there is one email later where he says he has personal knowledge of, how Mr. Hawk stays at the address that he contends is his actual residence, which is in Bostic. So there is at least a little bit there, and so it'd be for the board, for you all to decide, is it speculative enough, or is there enough there to advance an evidentiary hearing, or is it just speculative enough where you just haven't met that standard for the probable cause standard?
Adam, I have a question as well. He was the only candidate. That was 100% of the vote was his. So if somehow through this process, he were to be declared not residing within the jurisdiction, what happens then?
So our best read of it is that, say the protest went forward, eventually it was successful, he was found to not be residing in the district, therefore not eligible. Rather than a new election, since there would be no candidate for the new election, it would just essentially be a vacancy. There'd be a holdover on the county commission, and then there'd be a vacancy that would be filled. And there's a statute in Chapter 153A for the counties where it says that vacancy is filled by the remaining members of the county commission.
Thank you. All right, members of the board.
I have a question, I think, for Mr. Stevens. First off, the protest form that was filed, is that sworn to? Or is it required to be accompanied by affidavits? What status of that?
So there's not a requirement that you have to present your witness testimony through an affidavit. But I'm just pulling up the appeal form so I can answer your question in full about whether it's sworn, but
I guess what I'm getting at, if I allege something in the protest, is that enough to establish probable cause?
it is if you put forth enough facts where you think, okay, they've said, and it is sworn. So have they put forth enough like specific allegations there that you think that it reaches that standard where, yeah,
My second question is the protester is a different person than the challenger back in January, is that correct?
that's correct. The challenger in January was a different voter.
And then I think my last question is, you're talking about residency, is it at the time that they filed or at the time of the election?
So in a candidate challenge is at the time that they filed. So that's why the question was really, Mr. Hawk, where are you residing whenever you filed your candidate form? I can't remember exactly when in December it was, but sometime mid-December. The protest here, it's about essentially at the time that he's elected. So
Right, so that really could have had different answers at different times.
that's correct. And just for your first question, the protest form does require that it says by signing the protest application, you affirm the following, swear under penalty of perjury. Everything you provided in here is true to essentially the best of your knowledge.
I'll say this, residency requirements are loosey-goosey. I don't like them, but that's the way they are. We've had this presented before. But perhaps in this case, they should have let him put his evidence on.
Okay, Mr. Carmen, you're the only one that's been quiet here.
I think everything.
All right, so Mr. Eggers has made a motion. I don't recall, was there a second to the motion? Carmen seconds. We ready to vote? Okay, all in favor? Well, let's just go one by one.
I believe the motion was to deny the appeal of Keith Hunter based upon the January 2024 decision of the county board, as well as the finding that the remaining evidence would not establish probable cause to find that there was an issue with the residency of the candidate.
Okay, we're ready to vote? All right, Mr. Carmen,
Aye.
Mr. Eggers,
Aye.
Ms. Millen,
No.
Mr. Lewis. Oh boy, that brings it to me. I'm really conflicted by this. But I'm going to vote aye with Mr. Eggers and Mr. Carmen because we've been through this before. And I think the likelihood of a changed result is very small. And so the motion fails. Do we need? I'm sorry, it's been a long day already. The motion passes and the appeal is denied. All right, the next item on the agenda is the request for protest subpoenas from Judge Jefferson Griffin. Paul, you want to take the lead on this?
Sure, and before we get into it, just a housekeeping matter I need to raise with the board. 15 minutes before the board started its meeting, Mr. Griffin filed a motion to disqualify one of the board members from all proceedings in the protest. Obviously, it came so close that no one has had a chance to even review it or respond to it. So my recommendation would be for the board to table this issue and for the member or the members to consider that motion and allow the other side, if they would like to respond to it as well, for the board to take this issue up at a later date, because the issue that you would be considering is encompassed within the motion to disqualify.
Do we have copies of that?
It was emailed to me. I emailed it to the board. I can print copies now if you'd like to.
Do you have a proposed date for when we would take this back up? I'm mindful that there is a timeline on this, and we are dealing with an evidentiary issue that would potentially derail our process and our progress.
I don't, but the board is within its discretion to set that.
Okay.
I'll defer to my colleagues, but I think this is worthwhile for us to just stand in abeyance for 5 minutes, get copies of the request, and then we'll figure out what to do.
My email in openings, many copies.
Mr. Chairman, would we want to proceed with the rest of our agenda, and perhaps we can take this up after our closed session? That would give staff time to prepare copies for us.
Well, I think it's a good idea, Mr. Eggers, to at least move on, and then when these copies are available, we can decide at that point what to do next. So we're gonna defer consideration of the next item on the agenda. I think the next item is waiver of campaign finance penalties. Is that correct? Staff, have I skipped over anything? Apparently not. Lindsay, you're on.
Good afternoon, board members. We have a limited batch of waiver requests for your consideration today. As you are all familiar, we've had many agenda items like this before, but the state board has the authority under 163-278.34 to waive a late penalty for a late campaign finance disclosure report if it determines there is good cause for the waiver. So consistent with our past practice, state board staff have developed recommendations for the state board to consider today. In this case, all the recommendations are to grant all of the waiver requests that are being presented. The vast majority of these relate to the 2023 mid-year and year-end semi-annual reports, and the majority are being recommended for a waiver based on the fact that it is either the first late report of the committee or it is a late report that had no activity and occurred after an election for the candidate who is requesting a waiver. Copies of the waiver requests, a spreadsheet summarizing staff research and staff recommendations were provided to the state board in advance of the meeting, and we've also posted copies of the public board materials on the state board's website. I do apologize because I know the one document I have put in front of you today is in very, very small print and is probably difficult to read. So hopefully you had a chance to take a look at that prior to the meeting today, but I'm happy to answer any questions you have or to read anything from the spreadsheet that you are unable to read given the font size.
Mr. Chairman,
Mr. Lewis.
I have reviewed all the information that was emailed to me early in the week, and I'm prepared to make a motion and you're ready to accept it.
Yep.
Having considered the written request of the committees, I move that the state board find good cause to grant the waiver requests recommended by staff at this meeting and direct staff to provide notice to the committees that penalties have been waived.
I second.
All right, Mr. Lewis moves, Mr. Zanillan seconds. Further discussion or debate? Not so many as favor, say aye.
Aye.
Opposed, nay. Vote is unanimous. Let's see what's next here. Yeah, the waiver delegation. All right, so Lindsay, this is yours as well.
So thinking ahead to potential campaign finance penalties for the 2024 third quarter and 2024 fourth quarter report, and potentially even the 2024 year-end semi-annual report. We have already had numerous conversations with political party committees and with candidate committees from the western part of the state about how Hurricane Helene has impacted their ability to file reports for the third quarter. And we do believe will likely probably still have lingering impacts for the fourth quarter and the year-end semi-annual as well. So in anticipation of the waiver requests that are likely to come stemming from that disaster, we are recommending that the state board consider a delegation today to the executive director under 163-278.21 that would permit the executive director to issue a good cause waiver if the executive director finds that the late report resulted from the Hurricane Helene disaster. If the executive director cannot make that finding on any given waiver request, they would still be presented to the board at a future meeting, just like they would always be, and just like this last batch was today. The reason for requesting the delegation is really just to help these committees move through the process a little quicker. We are obviously at the end of an election cycle, so many of these committees may be looking to close and cannot do so until any outstanding penalties are resolved. So it will help move them through closure of their committee quicker and just simply to streamline the process for those candidates and those committees that have been most impacted by the disaster. And I'm happy to answer any questions you have about the delegation.
Thank you, Lindsay. Members of the board?
Yeah, I have one question. In the event we pass this delegation motion, if a waiver request is for some reason denied, board obtain authority to consider it later down the road. Was that correct?
So we wouldn't anticipate that the executive director would be denying any waiver requests. It would simply be that the executive director would be granting the waiver request if it resulted from Hurricane Helene. If the executive director could not make that finding, it would still come before the board to see if there were any other factors that could apply or for the board to ultimately make the decision on the denial.
All right, thank you.
Mr. Chairman, the only thing, I think this is a very good idea, having been very familiar with the damage caused by Hurricane Helene and knowing that there are a number of offices, including CPA offices, that were flooded and lost a lot of their paperwork, that this is a good delegation both for staff efficiency, for campaign committee efficiency, and for our own efficiency. I would like to put in a specification as to exactly which reports we're talking about. For example, it could be anything that is related to the 2024 third and fourth quarter year-end and semi-annual reports. And I perhaps even be willing to go so far as the first quarter of 2025, but I'll defer to staff just so that we know that what we're dealing with and that we don't have one of these pop up in 2029 saying that they need a waiver because of this hurricane.
And I think that that's certainly fine to include if that's how the board would like to proceed. I would note in terms of 2025, there are actually no quarterly reports due in 2025, so it would only be the 2025 mid-year semi-annual that would be impacted. One thing I would just say, keep in mind in terms of duration of this, waiver requests do need to be filed within 60 days of receipt of the penalty assessment. We're obviously still a little ways away from even penalty assessments being sent out for the 2024 third quarter report. But certainly if the board wanted to limit to, I think I would recommend it would be the 2024 third quarter report, the 2024 fourth quarter report, the 2024 year-end semi-annual report, and then the 2025 mid-year semi-annual report. And I guess the only other thing I will add to that, I don't know the volume of municipal elections we may have had in Western Carolina in 2024 here as well, but we would certainly want to be able to also capture any 2024 municipal report. So I would recommend adding that to the motion as well. And those vary, so it may probably easier just to refer to it as municipal reports as opposed to listing each.
All right, Mr. Eggers, it sounds like you need to make this motion.
I think I'm the official delegate from the West. So, Mr. Chairman, I would move the State Board delegate to the Executive Director the authority to waive civil penalties for filing late campaign finance disclosure reports if the Executive Director finds that the late report resulted from the Hurricane Helene disaster and that such a report is either or all of the 2024 third quarter report, the 2024 fourth quarter report, the 2024 year-end semi-annual report, and or the 2025 semi-annual mid-year report, as well as associated municipal elections reporting. I'll defer to Ms. Wakely to see if that accomplishes what she needs.
Yes, sir. Thank you.
Thank you.
Okay.
I second.
All right, moved by Mr. Eggers, second by Mr. Carmen. Further discussion? Not so many as favor, say aye.
Aye.
Opposed, nay. Carries unanimous. All right, Paul, you're up next. Report of the settlement.
Thank you,
Thank you,
Mr. Chair. This will be a very brief item, and it does not require any action of the board. It's just a requirement of our statutes to make a settlement agreement known in an open meeting following the entry into that settlement agreement. So under the open meetings law, this is 143-318.11A3. It states if a public body has approved or considered a settlement other than a malpractice settlement on behalf of a hospital in closed session, terms of that settlement shall be reported to the public body and entered into its minutes as soon as possible within a reasonable time after the settlement has concluded. So in a prior meeting, the state board met in closed session to consider a proposed settlement agreement in a federal action entitled Green v. Bell. Western District of Carolina, the district for the Western District of North. It was litigation that was filed and under the National Voter Registration Act, the NVRA, and its requirement for states and local elections boards to undertake reasonable efforts to remove from the voter registration rolls those who have moved out of the jurisdiction or who have died. And so that case was filed probably 2 years ago, perhaps 3 years ago. It's been litigated to some degree in the court, and eventually the parties came to an amicable resolution. And the terms of that settlement agreement for public disclosure are that the settlement resolves the case entirely. Dismissal has already been filed by the plaintiffs. The agreement requires the state board to institute some monitoring practices to ensure that the county boards of elections are regularly conducting list maintenance activities with regard to notices that the state board provides to the county boards about deaths, which we receive from the Department of Health and Human Services Vital Records Agency. And then, these are death notices and death removals that are already required by law and are already directed to be done by the state board and according to board policy. The settlement agreement merely adds some monitoring and transparency practices to ensure that is happening as required. The parties cover their own legal fees and expenses in the settlement, so there is no monetary element involved in the settlement. So that is all I have to report, and I'm happy to answer questions if the board has any.
Members of the board? All right, hearing none. Thank you, Paul. Am I missing anything, or is it time to go into closed session?
I would recommend that the board go into closed session at this point to consider a matter that is confidential with regard to campaign finance investigations. And the draft motion is provided to you on page 38 of your memo.
All right. Will someone make a motion?
Mr. Chair, I move that the state board go into closed session pursuant to NCGS section 143.318.11, subsection A1, to prevent the disclosure of information made confidential by NCGS 163-278.22, subsection 7.
I'll second the motion.
Mr. Carmen moves, second by Mr. Eggers. All in favor, say aye.
Aye.
Opposed, nay. Carries unanimously. Thank you, ladies and gentlemen. We'll be back as soon as we can. If you could consider, well, what is it, a motion request? Paul, what is the motion for recusal? How would we entitle that?
Table the motion.
Well, it's whatever the board would like to do with it, but it's a request right now, but there's nothing on the table right now. I mean, it's just a matter that was noticed on the agenda.
Got it. All right. Well, we'll decide when we get back whether or not to consider the item on the agenda for today.